The sixth presidential election petition to be handled by the Kenyan judiciary. Our political affairs reporter Mremi Mwangi delves in three of the most controversial presidential petitions in Kenyan history as NASA prepares to go to court.
The rough journey through presidential election petitions dates back to early 1993, when veteran politician Kenneth Matiba moved to the High Court to challenge retired President Daniel Toroitich Arap Moi's win in the first Kenyan multi-party elections of 1992. In the petition, Matiba accused Moi of rigging the elections and instigating ethnic violence, particularly in the Rift Valley, as a scheme to intimidate and lock out Matiba's supporters from the polls. But Matiba suffered a stroke that paralyzed both of his arms following months of detention and torture. He couldn't sign the court papers. His wife signed the petition on his behalf. On this basis, Justice Riaga Omolo dismissed the Matiba petition. But the verdict would years later come to haunt the judge and cost him his job. In early 2012, the Judges and Magistrates Vetting Board found Justice Omolo unfit to serve on grounds that the Matiba ruling had demonstrated his disrespect for the disabled. But the judiciary was yet again on the spot after the second multi-party elections of 1997. This time, then Democratic Party presidential candidate, retired President Mwai Kibaki, was challenging Moi's re-election. To notify Moi and the Electoral Commission of his intention to go to court, Kibaki published notice of his petition on the official Kenya Gazette. But he was in for a rude shock. A three-judge bench comprising Justices Emmanuel Kubasu, Msaga Mbogoli, and Moijo Olekeiwa struck out the petition on the basis that Kibaki's lawyers had not physically served President Moi with the court papers.
I'm the longest-serving judge in this republic.
But this verdict would in the year 2016 come to haunt Justice Mbogoli, who had applied for the Chief Justice job.
Kibaki and Moi, which of course you've been asked about, and which decision you seem to regret. Do you regret the decision?
That was a three-judge decision. And when you conference, when you retire to chambers and you conference, you may not have a voice, even if it's a dissenting voice, in a ruling of that nature. I'm not saying that I had a contrary decision from my colleagues who are there, but that one did not cross our mind at that time about substantive justice under that article of the current constitution.
But arguably the most memorable presidential election petition was that filed by opposition leader Raila Odinga at the Supreme Court in 2013, challenging the election of President Uhuru Kenyatta. After the constitutionally mandated 14 days hearing the petition, a 6-judge bench chaired by retired Chief Justice Dr. Willy Mutunga unanimously upheld Kenyatta's election.
The manner in which the court handled that petition was a travesty of justice. The court decided all interim applications in favor of Mr. Kenyatta.
David Kenani Maraga.
The spotlight now turns to the current Supreme Court bench, chaired by Chief Justice David Maraga, as Odinga prepares to file his petition against Kenyatta's re-election.